Please be ready for a dictation of Part 3 of the Supreme Court Judgement in Civil Appeal number 10827 of 2010. 5 seconds. Start. It is usual that businessmen often do not sit over nitty-gritty in a contract. In a document, the language used by the parties may have more than one meaning. It is ultimately the responsibility of the courts to decipher the meaning of the words used in a contract, having regard to a meaning reasonable in the line of trade as understood by parties. It may not be out of context to state that the development of rules of contractual interpretation has been gradual and has taken place over centuries. Without going into extensive study of precedents, in short, we may only state that the path and development of law of interpretation has been a progress from a stiff formalism to a strict rationalism. It is clear from the reading of the contract that the parties had intended to transfer business from appellant to respondent during the contractual period. This agreement was not meant as a lease or license for the respondent to conduct business. However, the respondent contends that the meaning of the document should not be culled solely with reference to the language used in the document. Rather, extrinsic evidence needs to be utilized before adducing proper meaning to the contract. In this regard, he submits that on consideration of all the intrinsic evidence, the contract should be read as a leave and license agreement, which is covered under the Bombay Rent Act. He draws his support from Section 95 of the Indian Evidence Act to state that the document needs to be interpreted having regard to external evidence such as receipts of payment under the contract, addressed as rent receipts, etc. It may be noticed that the High Court had appropriately identified the question of law in the following manner. The debate, therefore, revolves around the question as to whether the agreement of 7th February 1963 was a license to conduct a business in the premises or was a license to run the existing business which was being run by the respondents in the suit premises. Does the document create an interest in the premises or in the business? The High Court, in order to answer the question, utilized Section 95 of the Evidence Act, which reads as under. Evidence as to document unmeaning in reference to existing facts when language used in a document is plain in itself but is unmeaning in reference to existing facts, evidence may be given to show that it was used in a peculiar sense. Illustration: A sells to B by deed my house in Calcutta. A had no house in Calcutta, but it appears that he had a house at Chhabra, of which B had been in possession since the execution of the lease. These facts may be proved to show that the deed related to the house of Chhabra. Aforesaid section is part of Chapter 6, which deals with of the exclusion of oral by documentary evidence, containing Section 91 to 100. Section 92 reads as under. Exclusion of evidence of oral agreement when the terms of any such contract, grant or other disposition of property or any matter required by law to be reduced to the form of a document have been proved according to the last section, no evidence of any oral agreement or statement shall be admitted as between the parties to any such instrument or their representatives in interest for the purpose of contradicting, verifying, varying, adding to, or subtracting from its terms. Proviso 6. Any fact may be proved which shows in what manner the language of a document is related to existing facts. It is manifest from these two sections that it is only in cases where the terms of the document leave the question in doubt, then resort could be had to the proviso. But when a document is a straightforward one and presents no difficulty in construing it, the proviso does not apply. In this regard, we may state that Section 95 only builds on the Proviso 6 of Section 92. If the contrary view is adopted as correct, it would render Section 92 of the Evidence Act otious and also enlarge the ambit of Proviso 6 beyond the main section itself. Such interpretation provided by the High Court violates basic tenets of legal interpretation. Section 92 specifically prohibits evidence of any oral agreement or statement which would contradict, vary, add to, or subtract from its terms. If, as stated by the learned judge, oral evidence could be received to show that the terms of the document were really different from those expressed therein, it would amount to according permission to give evidence to contradict or vary those terms, and as such it comes within the inhibitions of Section 92. It could not be postulated that the legislature intended to nullify the object of Section 92 by enacting exceptions to that section. Stop.